selling a freehold that is subject to long residential leases is quite different to other types of conveyancing, and that's because of the leaseholder's right of first refusal. So this is a right enshrined in law which states that before a freehold that can be sold, it must be offered to the qualifying leaseholders. And so there are a set of qualifying rules that will need to be looked at, but generally speaking, if there is a freehold with residential long leases, so that's anything that was more than 21 years when the lease was granted, which covers most leases, and there's at least 2 of those flats within a building, it's going to qualify, subject to a few exceptions. Now, it's important that before a freehold is sold to a third party, it must be offered for exactly the same terms to the leaseholders by way of a formal Section 5 notice. And so it's got to be more than something like an email or a letter. It must be a Section 5 notice that complies with the legislation. And then the leaseholders are allowed up to 2 months to accept that offer. Now, it is an offence to not offer the freehold to the leaseholders, and so it's extremely important that the Section 5 notice procedure is followed, and it's also important that the terms are precisely as they would be offered to a third party. If there's no acceptance within 2 months, then the freehold is free to sell to whoever they wish, as long as they sell it on those terms. And if for any reason, following negotiations with a third party, the price changes or something along those lines, you need to serve the Section 5 notice again on the leaseholders, offering the new terms.